Ευχαριστώ πάρα πολύ, Στέλλα. Ευχαριστώ πάρα πολύ και τον ΕΟΔΙ και την Νομική Βιβλιοθήκη για την τιμή να είμαι το πρόσωπο το οποίο θα συντονίσει την πρώτη συζήτηση η οποία θα γίνει σήμερα. Let me now switch to English as we have with us two prominent international practitioners and people who are very much into mediation, Nadjia Alexander and Bill Marsh. Bill Marsh is based in London. He is, as I said, one of the most prominent mediators worldwide. He has been appointed twice as the Global Mediator of the Year. While Nadjia Alexander is, apart from a practitioner, a prominent professor on mediation, and she works at the SNU in Singapore. And she also is one of the editors of the leading commentary on Singapore Convention. So I think that we are very lucky to have these two people with us today, and in order to discuss which are the trends worldwide in mediation. So I would now like to pass the floor to Bill and Nadjia to discuss by posing a question about what they perceive to be the role of a lawyer in mediation. And I'm saying that because in Greece, where mediation is in its early steps still, there's a concern about how lawyers are willing to participate in mediation, how much in favor they can be.
Evaristo Harris, and Kalimera to everyone. I'm sorry that's the extent of my Greek, so thank you for tolerating us English speakers. Listen, this is an important question. It's very commonplace right around the world to hear reservations expressed in the legal community about the introduction of mediation. We've had exactly that in my country when we began. It's also very common, actually, for those reasons only generally to apply early on. So there is a transitional phase in most countries in which the understandable concerns that people have tend to get resolved, and they tend to get resolved on the back of experience. The one thing I think that experience of mediation brings to lawyers is an awareness of the centrality of their role. It interests me a lot that there is sometimes a feeling that lawyers don't have a valuable role to play in mediation. I have to say that's not been my experience. My experience has been that lawyers, if they embrace the nature of their role, which of course is different from other processes, if they embrace that, do have an absolutely central role to play. Things like risk analysis. So how does a party in mediation make a good decision? Well, they need to make it partly on the back of the legal advice they're receiving and the risk analysis they're receiving. So I think that attribute, that skill in lawyers is something that is drawn out by the process. I think support is extremely important. I was mediating, for example, yesterday in a case where a young man is caught up in a fraud which was perpetrated by other members of his family. So he's on the edge of the fraud a bit, and for that reason, he's also caught up in the litigation. He's being sued for tens of millions of euros, so he needs the support of someone with him in that process who can help him make good decisions, and I saw that very clearly just yesterday. So I've come to feel over time that lawyers have an absolutely central role to play in mediation. Yes, it can be different, obviously, from the role of an advocate in a court or arbitration process, although there are overlaps, it's important to say. But the role is nevertheless very important. I can think of mediations where the fact that lawyers were present has been the reason for the mediation resolving. I could also think of a few cases where the fact that lawyers were present was the reason for the mediation not resolving. And that, in a sense, points to the importance of the legal profession in embracing this and asking itself the question, how can I best contribute? And I think the key to this, possibly the easiest way to understand it, is simply to look at the websites of many law firms, particularly international law firms, all of whom will refer to their experience in mediation. And that tells you something. It tells you that it's become a process that these firms want to promote their involvement in and be seen as having skills in. And as I say, that's particularly so on the international scene. And I think there are probably two particular drivers for that, and I'll finish on this point. One is client demand. There's no doubt that there has been a demand from the commercial client base in many countries, certainly in mine, for the use of this process. And frankly speaking, if the clients want it, then it makes sense to be able to embrace it. And the other actually is credibility. I think it's now seen that having some skills in advising clients in mediation is seen as a really important mark of credibility in the legal community because it's so important to the client base. So that my day-to-day experience is I understand the caution initially. I've not found it to continue beyond a transition phase. And in fact, quite the opposite. I found it to become an area where lawyers actively want to promote themselves.
Could I just jump in there, Nadjia, and just add something? I couldn't agree more with Bill, and I think it's, it comes with lawyers and experience with mediation, and I also see a generational difference. So when I'm working with young lawyers in a university context, there's a real thirst for mediation, and that's not just in Singapore. I've seen that throughout Asia, Australia, also when I was working in Europe. I'm not sure about Greece, but an absolute thirst for it. And in terms of the transition, I remember very concretely when I was living and working in Australia. In the early 1990s, there was a rule introduced to the courts that the courts could mandate mediation, right? They could. And then the courts tracked the number of mandatory referrals to mediation. 10 years later, they tracked it again. And they still had this rule, but there were hardly any referrals to mediation. Yet the number of mediations was about the same because the courts were just referring everything at the time to mediation. And what you saw was that the lawyers, the culture had shifted, right? So that the lawyers, for whatever reason, probably thinking first, well, we'll be sent to mediation anyway. And also those having experience saying, actually, it wasn't so bad. And in some cases, it's really good. That lawyers were applying to the court for what we call consent orders, right, to mediate. Why consent orders? Because then they were covered by this particular piece of legislation, right, which had benefits for them. And so that's, I think, a really concrete illustration of a massive cultural shift. I was in a very exciting meeting this morning about reviewing the curriculum at our university in the law school, and one of the fundamental questions was, what are we educating lawyers for? And it came, is it for litigation? And absolutely not, right? How many cases end up in litigation? And so, one of the ideas that we're playing with is now implementing negotiation and mediation into core courses. And I know that's maybe taking us a little way away from the topic, but I think that's also part of this cultural shift. When you do contract law, do you also learn about interest-based negotiation, for example?
Yeah. In fact, if I could just chip in one more remark following up that point, exactly. I think a lot depends how we characterize legal practice and what it is we're trying to deliver. And I speak as a lawyer myself, though I haven't practiced as one for a long time since becoming a mediator. But I think that if you think that the role of being a lawyer is to use a process well, then that takes you down one route. If you think the role of being a lawyer is to enable the client to attain their priorities, that takes you down a different route. And I think the legal profession has been getting used over the last couple of decades to viewing itself much more in terms of client outcomes than in terms of the processes that we're comfortable with.
thank you both for these. Yeah, sorry, do you want to say anything else? No, sorry. So actually, thank you both for these thoughts, and I would keep 2 points out of them. One is the need for the lawyers to change perspective in the way described by both of you, and be the persons who actually assist in the resolution of the dispute. I also keep the generation issue that Nadjia mentioned, the fact that younger lawyers in general are more prone to mediating in comparison to older generations. And I also keep the fact that at least in SNU, you're discussing about introducing more and more mediation classes for lawyers. And the obvious question for me is, how about training of graduates? I mean, of practicing lawyers. This is a trend which is very strong in my country, at least. And I actually wonder to what extent you think this could also be of assistance.
At least in the work that I'm doing, we through the university, but you know, obviously lots of other places do this as well, conduct negotiation and mediation training actually at a university level, which leads to accreditation. And also, and I think this is really important to what we were just talking about, mediation advocacy training, right? Because there are many more people who are going to be lawyers who are going to be advocates in a mediation than actual mediators. But so we've just launched a graduate certificate in mediation and dispute resolution for exactly this purpose, with a training like a module on dispute resolution advocacy, half of which, right, which covers all sorts of dispute, but half of which is dedicated to mediation advocacy, right, with a quarter on litigation and a quarter on arbitration. Which for me is representative, I think, of this, of the shift, recognizing the shift that's already happening in practice, as Bill talked about.
Right.
I find myself in a law firm minimum once a month. I say I mean by Zoom at the moment, but normally in a law firm at least once a month, delivering training on how to use the process in the best way for your clients. It's absolutely central, and that shouldn't surprise us.
Actually, I've just thought of this. I'm not very good at giving commercials, but we've just launched a YouTube channel, and we have this video on it on mediation advocacy, with three lawyers, right, who actually act as lawyers in mediation. I'm sitting there and having a chat about mediation. So don't ask me I don't even know how to get onto YouTube, but anyway, if you, I'll find a link and send it to you. And if anyone's interested, I mean, they're all.
That would be fantastic. Yes, that was fantastic.
We just launched it yesterday, but they're three practitioners, right? People who are at the core of a talk, with slightly different views, but all talking about how they've implemented into their work. Yeah.
That would be very, very helpful. Thank you. And so, I mean, having discussed all this, I think that we need to train lawyers on advocacy in mediation, and I think this is what should be the takeaway of this first round of discussion. And a second question, which I think is also very important, is whether there are particular types of disputes that are more suitable for mediation in your view. Nadjia, Bill?
Yeah. So I think it's almost better to change that question around and say what sort of disputes aren't suitable. I think with my academic hat on, the empirical research over decades has absolutely, without a doubt, shown that there are not particular legal practice areas more suited to mediation. That's not true, right? Some people tend to say, oh, family is much more suitable and commercial less, or intellectual property less. But actually the research doesn't show that at all. It's more about the dynamics of the disputants, the parties themselves, the dynamics of the actual conflict or dispute. And sometimes even when people are resistant to mediation, a mediator or also a requirement to mediate can help them save face, right, and get them to the table, right, to mediate. So certainly, you know, mediation's not magic; it's just mediation, and not every case is suitable. But I think that, you know, I think it's not useful to say that certain types of legal categories of cases are more suitable than others. Bill?
Yeah, I think that I completely agree with that. I think for a long time I tried to work out if there was some way of defining cases that were suitable. So there was a kind of golden rule that we could apply. I've come to the conclusion there isn't. And I think the way I come to that conclusion is, excuse me, by looking at my own diary. If I look at my mediation calendar, it has an extraordinary range of different kind of cases. They could be banking, they could be family business, they could be fraud. I mediated a case, Haris, where you were representing your clients in it, which concerned the olive oil business. So you know, there's a different one. So the subject matter of the case, just from my own experience, doesn't make any difference. The timing of the mediation, I mediate cases that are before proceedings are issued, during proceedings but before the trial, and sometimes after the trial but before the appeal. So that doesn't seem to make any difference. I mediate cases involving points of law or points of fact or points of human emotion. That doesn't seem to make any difference. Some of them are very high value, some of them are very low value. Again, that doesn't make any difference. Some have ongoing relationships, some don't. So that's not a factor. Some are very kind of emotional cases, some are very practical cases, some are UK based, some are international. So honestly, I have given up trying to find a golden rule, because I can't find one. I just look at my diary and it has such a range of cases that I don't think. I do think the timing question is important. And we might touch on this, or I could touch on it now briefly. I think when cases come to mediation either too early or too late, it can be harder, not necessarily impossible, but harder. So when it's too early, maybe the parties say, or their advisors say, we haven't really defined the problem enough here to know what it is we're resolving, or we haven't collected enough evidence through the litigation process. Sometimes people say that. If it's too late, sometimes they say, look, it's only a week before the trial. We've spent all the money, it's not here, we might as well carry on. So those might be two balancing questions, but fundamentally, I don't think there are golden rules.
Okay, let me make things a bit more difficult on that, if I may. If you were to step into the shoes of any legislator in the world, be it the Greek, for example, where we do have compulsory mediation as as a standard thing these days, in a particular way, rather than opt-out approach. But anyway, this is what we have, and there's a kind of a horizontal sort of inclusion of a huge number of potential kinds of dispute. I would say most disputes, with small exceptions, that would be the rule. Do you think that this reflects what you said, that actually there are not any suitable disputes for mediation? Or would you, as I said, if you were to step into the shoes of the Greek legislator, be prone to choosing some types of dispute, despite what you said?
A good question. I think, I mean, it brings us on to the question of mandatory mediation generally. And let me say, I'm very reluctant to step into any legislator's shoes.
I'm sure you are.
But I suppose my challenge would be this: that do we make mediation mandatory because of a failure to build understanding and demand, or do we make it mandatory because we think it's the right policy? And I'm afraid I think some countries have adopted mandatory mediation because they have failed to build a culture of mediation within the legal process. I think the other thing I'd say actually is that the question is not really binary. It's not mandatory or non-mandatory. There are many, many different options. You could have fully mandatory. You could have, as we have in this country, penalties for refusing to use mediation in certain circumstances, but you could still refuse if you want. You could have encouragement to use mediation, so some countries will refund part of the court fee if you use mediation. So that's an incentive rather than a penalty. Some systems have an opt-out system where the assumption is the case will go to mediation, but you can opt out in certain circumstances. So I think we need to be, I would encourage, if I was a legislator, encourage a view of this that is not binary. It's not either mandatory or voluntary. And I would look at the options between the two. And I think the range of cases I do, the difference between that and mandatory mediation is that in those cases, most of them, the parties are choosing when the moment is right for them to come to mediation. And that's harder to get to that if it's a mandatory system.
Nadjia?
Yeah, I'd build on this idea of reframing the whole mandatory issue and talking about incentives, the strongest incentive being all of these cases or all of this category of cases must go to mediation. When I was talking about my example in Australia before, that was, you might label it discretionary mandatory, right, where a court had the ability, but they looked at it on a case-by-case basis. So I actually think, and I might differ from Bill slightly in this, I think jurisdictions can help to shift culture through incentives, some of which may be stronger, some of which may be softer. And as Bill said, there's a whole range of those. And, I think, behavioral economics tells us, nudge theory and all that sort of stuff. Bill mentioned opt-out, but also our experience tells us that nowhere in the world has a country or a population or a culture shifted dramatically to embrace what I'll call contemporary mediation without some types of incentives, right? Whatever they might be, but they do need to be, and I think Bill might have touched on this as well, giving people, and this isn't necessarily my view, this is what the research in behavioral economics will tell you, giving people the sense that they have choice, right? So apparently, we don't have any choice. We think we do, but advertising rules our lives, all right? But it's the same thing with every choice that we're offered, okay? So when we feel we have choice, we're more likely to, or we have a little bit of choice within a framework, we're more likely to embrace it. And I think there's a real art in this regulation of mediation that needs to, that we need to take into account.
That's a very, very interesting remark. And if I can go back to what Bill said, I would think that in Greece, yes, the legislator actually tries to build a culture by introducing compulsory mediation. And I would also say that the prevailing idea is that we are trying to also reduce the workload of courts. So there's a kind of a mediation is seen as a tool as well to reduce workload on courts. And honestly, I would like to ask you, how do you see this? I mean, is this the right approach to use that, mediation, in order to achieve another goal? Or should mediation be, I wouldn't say a goal per se, but I would say a very interesting tool among the other tools of dispute resolution?
I suppose my instinctive response to that is that it depends which hat you're wearing. If I was the Minister of Justice, of course, I would see the value in streamlining the court process and trying to find ways to promote a greater number of cases resolving by consensus. That would be inevitable. I've also worked in jurisdictions where mediation reform is seen as a way to reduce the legal aid budget. as well, because there was a hope, a misplaced hope, that the mediators could also somehow give advice to parties who were not legally represented. So I think if you are a state facing, as all states do, very tight financial constraints, I can understand if there is a desire to do that. If you wear a different hat and you are a party to a court case, your only priority is what's the best thing in your individual court case. So there is a real disconnect between the priorities of the state and the priorities of each individual litigant. And that's just a reality that we have to accept.
Can I add something? I agree. I think it's a reality we have to accept. And I think it is possible, though, for policymakers and lawmakers to take into account multiple goals, right? So create enough space. There's a wonderful poem, which I can't remember, about fire and air. And it says that the air and the space between if you put logs of wood and make a fire, right? It's not just the wood, right? But it's the space between the logs and the air that's really important for the fire. And and I think it's also creating enough space in your regulatory framework that people can find their own goals, right? And I think there's also, as a mediator, there's a conversation often to be had, right, at the beginning of every mediation about, what do you want out of this process? Because they might be very different things. And a regulator, I mean, because you started this question with what would you do if you were the legislator, right?
Yeah.
There's the ability to create that space, right, for people to achieve their different goals. And one interesting trend that you see around the world is many legislators, they began with courts mandating mediation or just legislation saying all these cases have to go to mediation. Then you saw a wave of legislation or practice direction saying lawyers have this duty, right, to consult with their clients, to talk to them about mediation. And now you've seen in the last decade or so a new wave, which is putting duties on parties themselves and a corresponding duty on the lawyer to advise their party that they have a pre-litigation duty to try mediation where it's suitable. I think England has this as well, Bill, and it was probably one of the first, in fact. Hong Kong has it, Singapore has it, Australia has it at the federal level and other places. And so you see sort of the, almost sort of this obligation being, being placed, I guess, on different stakeholders and now ultimately on the parties themselves. But with that comes choice about when and how I will do it, right? And the ability to opt out if you've got a good excuse.
Absolutely. Which comes back as well to the point we were making earlier about there being such a wide range of possibilities. It's not either mandatory or non-mandatory. There's actually a big, I'd like your phrase, Nadjia, regulatory space. And there are discussions to have. And in fact, I think where progress has been made best, it's often as a product of conversations, serious strategic conversations between the different stakeholders. So that's the government, the mediation bodies, the legal bodies, maybe input from the what you might call the client base, from industry groups and so on. There's a really serious conversation to have about what people want from the justice system as a whole. And the more that conversation takes place in a way that embraces the different stakeholders, I think the more likely you are to end up with a system, as Nadjia says, that meets multiple aspirations and priorities.
Yeah. So I keep, as Bill, as you just said, the idea of regulatory space. I think that should be the major takeaway from this round of discussion. And I would say, if I understand well, that there is also a need for adjustment. I mean, it's kind of a trial and error process for finding the right way to address compulsory mediation in every single state. So, I mean, you try to start somehow, and then you may see that this does not work as you have imagined, and try to, readjust things in order always to create this space for the parties to feel that they are free to settle their dispute the way they want, or to proceed to court if they, or to arbitration if they think this is more suitable.
And Haris, I think that's exactly why it's important not to legislate everything, right? If we're talking, I mean, we're talking now about mandating or triggering what triggers the mediation process, right? And I think and if you want to be able to adapt and to change and to be agile, which is what you're talking about, and if everything is in legislation, it's harder to change, right? Which is why it's good to have softer forms of regulatory triggers for that. I mean, the main bit about, the main thing about mediation that needs to be super flexible is the process, right? There are other bits about mediation like confidentiality and rules about admissibility of evidence that need to be probably legislated. That's really important, right?
Yeah.
But the triggers are also something which I think, as you said, it's trial and error to see what works in a particular cultural space.
Yeah, yeah. And if I may add on culture, I would also, this brings to my mind an article of yours a few years ago that was a comparison between the German and the Australian system on mediation, if I remember correctly, Nadjia. And I understand you also brought there the dimension of the actual legal system where mediation is introduced. In the common law systems, we have a more flexible approach anyway than we have in the civil law systems. So Greece being a civil law jurisdiction, I wonder, and the legislator in Greece plays a very important role, as you may appreciate. So to me, it sounds, on the basis of what you just said, as a kind of a disadvantage for countries like Greece. That, the legislator has, the wish to sort of intervene and resolve issues himself or herself, instead of leaving, society or the parties to find a way. Do you think?
Yeah, I mean, I'm not sure whether it's a disadvantage, but certainly there are different legal cultural approaches, and I think in the very early days of comprehensive legislation around mediation, I think Austria was one of not Australia, Austria. So it was the first countries in the world to legislate very comprehensively about mediation, civil law country. I remember the Germans were very jealous of it at the time. But later on, they realized they were probably lucky they didn't do that because, Austria had really, they put themselves into a straitjacket, and it was very early on in the sort of in the development of the profession, and they didn't have the flexibility to change as quickly or adapt, as they would have liked to. And I think, that's certainly a lesson. But I think what you see now is a lot of cross-fertilization between civil law and common law jurisdictions. You see common law jurisdictions learning also from civil law jurisdictions and adopting some of their ideas, and vice versa.
All right. That's very useful. If there's nothing else to be added at this round, there's another question which I think should be of interest, which is actually whether governments and government entities in general can participate in a mediation process. In this country, there's a reluctance. I mean, there are also questions of legality in a way as to whether the state can embrace, sort of can be part of the mediation process. So I would like to ask you, which is the trend internationally in this?
My experience has been that some governments are reluctant to and others aren't. I think where there is a reluctance, the two reasons that I come across most are these. One is the whole question of public accountability for decision making. So if you're a government, you need to make publicly accountable decisions, and there is sometimes a perception that mediation would not provide a context in which you could do that. I have to say, experience suggests that's not correct, and so does the theory of mediation as well, actually. But nevertheless, that is an often mentioned concern amongst governments. The other concern is that you need to find individuals willing to take decisions and accept responsibility for them. And these are compromise decisions, almost inevitable. That's not always easy. I did an investor-state mediation last year involving one of the Baltic states, and they were very, very clear to me about, the government, about just how difficult their individual positions were for those who attended the mediation, because it's so easy for them to say, let the arbitrators decide, and then no one can blame me. And in fact, to their credit, they did take decisions and took responsibility for them, and we were able to resolve it. But that's, those require people of a lot of courage. So those are the two reasons I find, practically speaking, for people to object. The experience, however, is not always the same. I mentioned, in fact, I did 2 investor-state mediations last year, one with an EU state and one with a non-EU state in Europe. And I've done others with African governments and so on. So it's perfectly possible. The other example is some years ago now, probably more than 10 years, about 14 or 15 years ago, the UK government made a public pledge that wherever it was in litigation and the other party wanted to use mediation, it would by definition agree. And there were one or two circumstances where it was not obliged to, but more or less everything. And so the government itself, for example, in a contract dispute, would use mediation. And those proved very, very popular. They published findings on the number of mediations. They published findings on the level of cost savings as well, which caused some interesting discussions. They reckoned in the first year they saved, I think the figure was 26.4 million sterling in legal costs from using it. So that was that engaged quite a lot of political comment at the time about the level of public savings. So it is possible. The reluctance is understood, but actually the experience demonstrates it's perfectly possible.
Mm-hmm. Nadjia?
Yeah, I'd like to add to that. I mean, I have a small mediation practice, nowhere near as extensive as Bill's, but certainly I've had government clients in that. From a policy perspective, I can think just offhand of at least 2 pieces of legislation, Hong Kong and Singapore, where there's an express provision in the mediation legislation that it binds the government. And some of you may remember, at least the less young among you, Crocodile Dundee. Right, I shared this with Harris and Bill the other day. So Paul Hogan was the Australian actor who played Crocodile Dundee in that famous movie. And I remember reading in a newspaper ages and ages ago, I can't even remember when, but at least a decade or more ago, that when he came back to visit Australia, he ended up marrying his co-actress and living in the United States. He came back to Australia, and there was a disagreement about how much tax he owed. And I think many people would think, well, this is not a matter for mediation. But as in England, every Australian government department has a dispute resolution pledge, and mediation plays a central part of that, including the tax department. And I remember reading subsequently that his tax dispute was resolved via mediation. Now, the details of that mediation weren't public, but it was transparent, right? That that it reached a mediated settlement in relation to that, and again, it's also a question of how you sell it, right? Where this saves a lot of resources, right? That's a big plus for a government, right? In terms of the appeal of mediating, yeah.
Absolutely. At this point, I would like to invite participants again to submit any questions they have. So that we can deal with them by the end of this session, or in the meantime, if you feel that this is pertinent. Another point that I would like to discuss with you is the question of international cooperation on mediation, be it regional or even global. We are talking about, of course, the Singapore Convention on enforcement of mediated settlement agreements. There are also regional arrangements like the European Union one. So obviously, there's a lot of work being done in this field internationally, and it touched upon also the legal aspects of mediation. So I would like to invite both of you to discuss this point. I think this is very important because it also shows what I see as a global trend in favor of mediation.
Okay, I'll jump in. So I mean, I'll leave Europe to the Europeans, including the English, if that's all right. But I think in terms of the Singapore Convention, I think it's too early to say what that might change. But I think the fact that you had 46 signatories, now there's more than 50. It was ratified within 12 months of its opening, shows the interest and the intention, right? Also among governments, to embrace this form of mediation. The other really interesting thing is that I think almost half of those initial signatories were from developing or least developed countries, right? And that also says something to me. That says particularly in cross-border, because the Singapore Convention is about cross-border, but where, cross-border doesn't have to be high-end commercial, right? So many things we do now are cross-border, and they're often not involving huge resources. And where you don't have huge resources, or you think you don't have a lot of, power, the flexibility that mediation offers is something which is of great interest, I think, to particularly to these less resourced countries. But I think more than the the Singapore Convention focuses just on one narrow thing, right, which is enforceability, right, like the New York Convention does. But beyond that, I think its greater importance is to really, support the visibility, the credibility, and the legitimacy of mediation as a standalone process internationally. And I think to that end, it's being a major success. Yeah. But it's still too early to see, to see the shifts in practice.
Yes, yes.
Look, I completely agree with that, both globally and from a European perspective as well. And as Nadjia said, despite our recent decisions, the UK is still part of Europe, even if we don't want to play in the same playground all the time. Apologies for that. It's about two things for me. It's about making justice systems work, and by work we have to ask ourselves what that means. And it really means that anybody who thinks their rights have been infringed has access to some sort of proportionate and affordable system for resolving them. And if you look at it in those broad access to justice terms, then I think we see the natural fit of mediation as part of that bigger framework. Only part, but nevertheless an important part. So I think that the access to justice lens is a very important lens through which to view this. And Nadjia's other point, with which I fully agree, is about credibility and legitimacy. I think that any time the state engages with a subject in a serious way, whatever that subject is, it lends credibility and legitimacy to it. And so these international state-level involvements in mediation, things like originally the UNCITRAL model law was the first sort of UNCITRAL effort at this, followed up more recently by the Convention on Enforcement. All these things are critically important, and they may have a direct effect, or they may just have a subliminal effect in enabling people to take more seriously the subject as the process as a standalone legitimate form of resolution.
Yes, and now that you mentioned UNCITRAL in general and the model law as well, for the audience, in case someone is not aware of this, there's a model law that has been drafted, prepared by UNCITRAL, and it can be adopted as the law on mediation by any state that participates in arbitration. It's along the lines of the similar model law on arbitration. So my further question to both of you is, we have on one hand arbitration, under the aegis of which both the model law has been prepared and the Singapore Convention on Enforcement. And in the EU, Greece being part of the EU, this is important for this audience, we have a different system, which is the EU system, which actually uses, there is of course, as we know, the directive that has placed the role of the model law in a way, if I can make a comparison. And on top of that, we have the right to use the various regulations of the EU relating to the enforcement of judgments or public documents from one member state to another, and that would play the role of that the Singapore Convention plays. The system is not the same, nevertheless, it serves the same purpose, I would say. So my question is, do you see any room for the EU to actually adopt as a whole, or for any member of the EU on an individual basis to adopt the Singapore Convention, or as the case may be, even the national model law?
I don't see that it's inconsistent at all. I mean, my understanding of the European directive is that each EU member state is obliged to regulate certain aspects of mediation, but they have scope in terms of how they choose to regulate it, right?
Correct.
Correct. And the Singapore Convention, and I know there's a lot of, there's been a lot of talk about, well, we've got the EU directive and therefore Singapore Convention sort of doesn't fit, but the Singapore Convention is one way to regulate enforcement, right? So they're not inconsistent. To my mind, there might be political sort of reasons for focusing on one rather than the other, but I don't see that they're inconsistent. And the model law, I mean, model laws, are really different, because model laws, countries can, legislators can pick and choose whichever bits they like of a model law. So insofar as, jurisdictions are reviewing their framework for mediation, because the Singapore Convention deals with just one tiny, important, but tiny piece of it, right? But insofar as there's any review of the regulatory framework for mediation, the model law can offer, some useful ideas, because there are many different aspects of mediation, that are regulated, whether or not they're specifically regulated or not, because you can't not regulate, right? If you don't regulate something specifically in relation to mediation, it's ultimately regulated by the general law.
Correct.
So the question is, do we choose how we want it to be regulated, or do we just let it happen by general regulation?
Yeah. Absolutely. And well, yes, Singapore Convention is about enforcement by all means. The directive is about enacting in every single member state how mediation will be made, and in that way, this is similar to the model law. I mean, the directive. So one further point is that in the EU, and I compare again with arbitration, the European Union actually abstained from regulating arbitration simply because of the success of the New York Convention. That was the rationale of this decision of the EU. Whereas in the field of mediation, there has been, the directive, even the use of the various regulation and enforcement of judgments that are used also for enforcement. So there's an effort of the EU to jump in. So I see a different way, a different approach on these two topics. Do you have anything to say to that? Does it make any sense to you, or?
I mean, I think I just go back to my comment is that there may be political, reasons to focus on one rather than the other. But I don't see, personally, I don't see any legal or practical reason that they can't coexist at all, right? In fact, the Singapore Convention, and there, you can go do a deep dive on this, which I won't, but the Singapore Convention was intended to be a gap filler, right? So that it doesn't affect, for example, Hague Convention projects and those sorts of issues. It doesn't overlap with the New York Convention, and it can sit and coexist with the European Directive. That was certainly the intention.
Yeah, absolutely. Okay, if there's nothing else to be added at this point, I was thinking about COVID and the new reality we are all experiencing these days. And I mean, if it were not for COVID, you could have been with us in Athens today. Yeah, next time, hopefully. So the thing is that COVID is not only about this conference. COVID is on everything. And of course, COVID, has an impact on how mediation is conducted. And also on cases that eventually end up to mediation. Do you have any comments on that?
I mean, I guess from a purely practitioner's point of view, mediation has, well, I suppose I'd start by saying the last 14 months have been my busiest ever as a mediator. So something is happening to make mediation continue. And it's all happening online. So I guess there are two aspects of COVID impact. One is the process, and I think the process has adapted to go online pretty well on the whole.
Mm-hmm.
And that's, in fact, there have been some advantages as well, I would say. So that where, with what we now have to call a traditional face-to-face, that sounds bizarre, but anyway, a traditional face-to-face in-person mediation. If I take as a reference point one of the investor-state mediations I did last year, previously I would have to go to the country, everybody would fly in, we'd all stay there and so on, and there would be a kind of an event, maybe 2-3 days, something like that. The way we've done it, in fact, because it's all been online, is to have a day here, and then I've sent the parties off to do some more work on this and think about this point and so on. Then we've come back for another day. So there is an inherent flexibility with the online approach that it's potentially there with meeting in person, but maybe less so, which is an interesting possibility. And I certainly have colleagues, although I'm not one of them, and I have colleagues who say they don't want to go back to meeting people. They just want to stay in their rooms and never go near a real person again. I think the other area, of course, of the impact of COVID on mediation has been the substance of the disputes. So I find now a lot of mediation about force majeure clauses, about insurance policies, and whether for example, whether a business interruption policy operates in the instance of COVID, because COVID wasn't something that anybody anticipated. So there've been a cancellation of contracts and all the rest of it. There've been a lot of cases where COVID has been in effect the cause of the dispute, and it's interesting me to see how many of those have very quickly embraced mediation. Just perhaps one example of the interaction between the law and mediation on this subject. We had a big fight here in the UK between the insurance industry and a lot of claimants under their business interruption policies. And so one case was taken as a test case. It went all the way through to the Supreme Court very quickly. The Supreme Court made a decision, and that decision now has to be implemented in each of the different policies. So that the opportunity was used to clarify the law, but the application of the law is now the subject of different mediations. So we now get lots of mediations where people are saying, this is my case, and I think it fits within the law. And the insurance company is saying, no, you don't come within the law. as pronounced by the Supreme Court. So it's a very, I think, a really important example, actually, of the way in which the law and the mediation process need to be symbiotically connected. You couldn't do those mediations without a Supreme Court decision. But equally, you don't want a Supreme Court decision for every single case. So that, you know, it's a lovely example of the two working together.
It is. It is. And if I may add, this actually answers, I mean, to me, that's a very, very important remark, because in this country, there is a concern about how, as you said, there can be a symbiosis of mediation with the law or the legal system in general. And there are, okay, this is a very extreme argument, but there are even concerns that mediation does not respect the right of the person to go to court. We all understand this is not the case, but I'm giving a very extreme argument of how some people see, as you said, the symbiosis between mediation and legal system, whereas the way you describe it, I think it's very, very useful example to understand how this can work really. Nadjia, you want to add anything?
Not very much. The only thing I in addition to what Bill said, notice is that we, for example, have shifted our training, even when people could come together, to do a hybrid training, because most people who are going out and even doing their first mediations are now doing it online, right? And we even had the situation where we first trialed this hybrid, so they actually have to do some of their simulations online and some of them face-to-face. And then we did the credentialing assessment, and two of our candidates, the first time we ran it, were in quarantine, right? Because they were in the wrong movie theatre at the wrong time. And so we literally had to do their credentialing assessment that way. But the few, you know, that have gone on and started doing some mediations have informally come back and said, that was just really helpful, right? Because we didn't have to do the first hurdle ourselves, right? We were familiar with, for example, how important it was to, just understand the basic functions of Zoom or whatever other platform they were using. Yeah. So I think it's the online or hybrid is the new reality. Yeah. And certainly in this part of the world.
Yeah. So we have like 4 or 5 minutes to go. There's one question from the audience by Vasiliki Pano. It's the question really is why, in your mind, although there's a number of signatories, around 60 of the Singapore Convention, there's only 6 or 7 ratifications, if I'm correct. Do you have an idea why? I understand the slow pace. This is, I think, is the underlying concern of the question.
Yeah, so I think I don't have statistics of the New York Convention in my head, but certainly there were 10 signatories on startup, and and ratification takes a long time in most countries. In fact, the fact that there was ratification within 12 months of signing was pretty fast in my understanding of those things, and certainly I think COVID has has put government's attention somewhere else, although it's arguable, given what Bill has said also, that it's exactly because of COVID that this should become a priority again. So I don't think it's slow for ratification processes that that have to occur using all sorts of different governmental systems around the world. My understanding is that there are quite a few, from talking with the UNCITRAL Secretary, there are quite a few in process, and we are, they are expecting a train of them coming along.
All right, and a very, very last question. I know it would take quite some time to discuss, but if we can squeeze it a bit, it's about the current trend of institutionalizing arbitration, in the sense that mediation is somehow linked with the court process. It is being monitored by judges, all this kind of approach. Do you have anything to say on that?
I suppose a brief remark would be that if you look at the origins of certainly mediation in the business community, it began with a desire on the part of business to do something, which is what you might call a bottom-up approach. So the people affected by it want to find something better. It's become, in many countries, a top-down approach, which is that in order to generate mediation, we need government initiative. And I think if we view it exclusively as bottom-up or top-down, then we miss some of the potential. So I really think that that there are too many, for example, governments who think that if you simply pass a mediation act, that everything else will happen. And of course, nothing happens because there's no bottom-up work. But if you only do the bottom-up work and there's no structure, then often there's no credibility and legitimacy to the process. So somehow the two need to be combined.
Nadjia?
Yeah, a couple of things. I think, there's the legal world of mediation, and then there's also many other worlds of mediation. So you can get to mediation as a party through the courts, through some institutionalized framework, or through your lawyer, but you can also get to mediation through HR professionals, in organizational settings, right? Or through word of mouth, or through many other, counselors or many other gatekeepers as well. And I think, there's a massive world that's actually bigger than the legal mediation world. There's a massive world of mediation out there that is affected less by the sort of institutionalization or regulation that we're talking about. And I think it's just important to keep that in mind as well. And, and lawyer mediators, which some of you may be, can also get referrals from these other sources, not just the court-based or the legal sources. And I think the other thing I would say is, building on what Bill said, I think there's a real art to regulating mediation. Right? It's back to the analogy of the fire with the wood and the space between the logs of wood that make the fire, and the top down and the and the bottom up, and you've got to balance consistency, right, with flexibility, right, and so you don't want to regulate everything in a rigid way, but some things do need to be regulated for predictability and certainty, but other things need that flexibility, because if you don't do it, it's only a matter of time before we'll be looking for another alternative, right, with another name, but it'll be the same thing. Yeah. Absolutely.
That was very helpful. I think that would be a major takeaway of our discussion today. I mean, consistency and flexibility at the same time for legislators, for mediators as well, for the lawyers in mediation as well. I mean, this is how the system should work. And I would like to thank both of you for this wonderful discussion today. I feel I've gained a lot today by discussing with you, and I do believe that this is the case with everybody in the audience. Before we go, for the audience, Nadjia and Bill and Nadjia are the co-editors of Clue and Mediation blog. I think much of what was discussed today, and much more than that, can be found at that blog. I think this is very helpful for anybody who wants to understand which are the trends in mediation in the world these days. So thank you both so much.
Thank you very much.
Thank you. Wonderful discussion. And have a great conference, everyone.
Thank you.
Bye.
Nadjia, Bill and Harris, thank you very, very much for the lively discussion and for sharing bits and pieces of your vast experience. It has truly been a pleasure to have you with us today. Προχωράμε με τη δεύτερη ενότητα, με θέμα τον ρόλο της διαμεσολάβησης στο πλαίσιο της αναμόρφωσης του οικογενειακού δικαίου, η οποία και βρίσκεται στο ζενήθ της επικαιρότητας, αφού το νομοσχέδιο για τις σχέσεις γονέων και τέκνων αυτή τη στιγμή συζητείται στην Ολομέλεια της Βουλής. Την ενότητα θα συντονίσει η κυρία Δήμητρα Γαβριήλ, δικηγόρος LLM, διαμεσολαβήτρια, εκπαιδεύτρια διαμεσολαβητών και επανορθωτικών πρακτικών και affiliate της Edwards Mediation Academy.